entitled Law, Religion, and the Family Unit after Hobby Lobby, a tribute to Professor Harry Krause. This afternoon, you are in for a treat because we have Bill Eskridge here to kick off the symposium by providing a keynote address. Bill, as you probably know from the printed materials, is the John A. Garver Professor of Jurisprudence at the Yale Law School. And I just wanted to say a few additional words by way of introduction. Bill Eskridge is remarkable in many respects. And you can read his bio and see his impressive credentials. Summa cum laude from Davidson College, Master's in History from Harvard, law degree from Yale, editor on the Yale Law Journal, law teaching positions at many great schools, including Georgetown, Columbia, Stanford, and since 1998, Yale. I could talk about his exceptional academic productivity, scores of books and articles put out by the most prestigious publishing houses and law reviews, or his noteworthy intellectual diversity. It's rare for a legal academic to become a true leader in even one area of law, and yet Bill is really a pioneer in two somewhat distinct areas: the dynamics of statutory evolution and judicial interpretation, and the equal and just treatment of sexual and gender minorities. Or I could discuss how Bill is one of the few academics I know who do high-level theoretical work and then effectively translate that theory so that it can be readily understood and deployed by judges and other policymakers actually doing law. And on that note, let me recognize two judges who are here with us today, distinguished guests. Judge Jennifer Elrod of the United States Court of Appeals for the Fifth Circuit, and Judge Deborah Walker, an alum of our college, from the from the Cook County Circuit Court. And the third judge is here. Are you pointing at somebody else?
I was pointing at Senator Adams.
Oh, and Senator Adams from Utah. I didn't know you stuck around today. Thank you so much. Bill is one of the few people in the Academy who does theoretical work that actually gets consumed by judges and other policymakers. So I could talk about all that, but what I want to emphasize instead is that Bill is a kind and nurturing person and colleague. He may not remember this, in fact I'm sure he won't, but I first met him by phone in 1991 when I was thinking about becoming a law professor. I remember it because I remember the particular conference room in the law firm I was working in where I was on the phone and I wasn't even sure I should be on a work phone talking about another job possibly to apply for. Bill was at Georgetown then. He was on the hiring committee, and he spoke to me for about a half an hour, giving me candid but not unduly critical thoughts about a number of schools to which I had applied. And although I did not end up at Georgetown, at the end of that year's cycle I took a position at UC Davis and UCLA, I still vividly remember how good my conversation with Bill made me feel about entering the legal academy that day, about how privileged we are to do what we do, and how as a result we need to use the tools we have been given to improve society. When I meet with entry-level teaching candidates, as I will do next month when our appointments committee goes to DC for the AALS recruitment fair, I often think that I succeed whether or not a candidate ends up at my school if she or he comes away from the interaction feeling the way I did almost 25 years ago after talking with Bill. So without taking up more time we could spend learning from him, let me turn the podium over.
Robin Wilson is an old friend of mine, as is Dana R. And I really appreciate the honor of speaking here to you all. What the Dean didn't mention was that I've spoken here last in the Bound Lecture back in the 1990s, which was the basis for my law review article savagely criticizing the Supreme Court's decision in Bowers and Hardwick. An article which was cited and plagiarized by the U.S. Supreme Court. Now, I don't know if the Supreme Court will want to plagiarize what I'm going to talk to you about today, because what I'm going to talk about today is an effort, I'm not going to talk about Hobby Lobby, unfortunately, but it is going to be after Hobby Lobby. And I want to combine my current project, which is I'm doing a history of the marriage equality movement, not just the groups and individuals that have sought marriage equality, but the groups and individuals and institutions that have been skeptical of marriage equality and have had different kinds of visions. I myself am a Presbyterian, but that means that I've been delving into the traditions of other faiths, other than the Presbyterian Church. And certainly the most interesting and moving for me is the Church of Jesus Christ of Latter-day Saints, often called the Mormons or LDS. And what I want to do is give you a summary history. There's a much longer version that's going to be in the law review of what I call latter-day constitutionalism, a very engaged LDS church seeking to push back against developments in family and family law to preserve safe spaces for the raising of children. And I want to tie that in to thoughts about constitutionalism generally, about religion, and about the centrality of family law and family to the U.S. Constitution. So that's my ambitious agenda. The thesis is set forth in the PowerPoint slide, and the protagonist of the story, the central figure, is Gordon Hinckley. Gordon Hinckley was the chair of the Special Affairs Committee, which was a political outreach committee that he founded in LDS Church, in a central point when the church was opposing ERA. He was later a counselor to the president from 81 to 95. That's part of the Troika that is the top group in the LDS Church. And then he was the president and prophet for a long period of time until his death in 2008. Hinckley is also the author of a very important document. I don't know how many LDS folks are there here in the audience. I'm not, I'm just being a sample man. It's a very fascinating religion. And many LDS families actually have President Hinckley's proclamation framed in their homes. It's basically one page. And it sets forth, it's a synthesis, I don't think that it sets new ground, it's a synthesis said in 1995 after the ERA defeat and near the beginning of the serious marriage equality debates, where the LDS Church sets forth its vision of the family. Now this is not everything in the document, but really is much of it. It's a very centrally gendered understanding of the family. It's a theology of the gendered family. And here are just some quotations for you. From the LDS perspective, gender is an essential characteristic of the individual, premortal, mortal, and eternal identity and purpose. Under the Mormon religion, we all have existences before we're born, and we all continue after death. Most of us, you'll be surprised to know, go to heaven. LDS is not a big believer in sending a lot of people to hell, though where you end up in heaven is very tiered, and you want to be in the celestial kingdom if you can. To get to the celestial kingdom, you need to follow this and more. The central commandment of the Lord is for his children to multiply and replenish the earth through the sacred powers of procreation, but employed only between man and woman, lawfully wedded as husband and wife. And if your marriage is sealed in the temple, you will probably get into the celestial kingdom, which is really where you want to be. Though the rest of it is pretty good too. Then finally, this gendered understanding of the family is by divine design, fathers are to preside over their families in love and righteousness and are responsible to provide for the necessities of life, and mothers are primarily responsible for the nurture of children. Now this idea of what I would call the Mormon understanding of the virtuous but gendered family, maybe virtuous and gendered family, is increasingly at odds with the trend in the United States toward what I call the hedonic and ungendered family. Hedonic is just simply a fancy word for the role of family is happiness, and not necessarily all of these larger goals that they might follow as well. The key variable in my lifetime, which is quite lengthy, is the role of women. And in my lifetime, almost on a yearly basis, larger numbers of women working outside the home, many of them in full-time jobs, increasing numbers, at least when I was born, postponing marriage and postponing childbearing. Many women, many men of course too, no longer even married. There's been an increase in my lifetime of non-marital sexual activities. The sexual activities have started earlier. You all are witnesses to that, and maybe even participants. There's been a rise in sexual cohabitation and non-marital births. No-fault divorce, though Utah, for example, comes late to this trend, marriage is no longer for life, and divorce is much easier than it was when I was born in the 1950s. Abortion and contraception are more available than they were 50 years ago, though it depends on the state in which you live. And this represents a separation of heterosexual intercourse from childbearing and childbearing. Marriage, sociologically, cited to Andrew Cherlin and other sociologists, has moved toward what I'm calling a hedonic model. And that is, marriage is individualized, and marriage is understood and experienced often as involving the happiness of spouses, with that as a greater emphasis than the idea of unitive commitment and self-sacrifice. They're not necessarily mutually independent. It's a question of emphasis. At the same time, and not unrelated, that women are emerging outside the home, that sexual mores have changed, the family has changed, LGBT persons, lesbian, gay, bisexual, and transgender persons have increasingly come out of the closet. Increasingly, in your lifetime, they've come out of the closet as couples, often committed couples raising children. That's been a major social phenomenon. Now, in terms of the LDS's constitutionalism, which is involved and engaged at a level not seen in my lifetime by other denominations, the goal of it has been, as a response to these changes in society, which have also been paralleled by changes in the law. So cohabitation is no longer illegal. It once was. Divorce is much easier. It was once very difficult. Marriage has been broadened. Abortion is not always legal, but much more so. Criminality has changed, et cetera, et cetera. And the LDS constitutionalism is a push back against this. And the story, at least my story, begins with the Equal Rights Amendment, proposed by Congress by huge margins in 1972, I believe in March, goes to the states within a year, about half the states ratify. By the time Utah takes it up in January of 1975, there are 30-some states that have ratified. It seems well on its way to becoming part of the Constitution, for which you require 38 states. In the mid-1970s, early mid-1970s, the first presidency comes out opposed to the ERA. This is a later statement, but it reflects their earlier views. Why is that? Because Mormon Utah has a long history of equality toward women. Jury service, voting, et cetera, women have played important roles in the LDS Church. So why does LDS take an opposing role for the Equal Rights Amendment? And here's their stated reason, which I think is the reason. Our Creator has especially suited fathers and mothers, this is the gendered theology of the family, to fulfill their particular parental responsibilities. And then here's the key part. And any legal development that could blur those roles gives cause for concern. Now then you ask yourself the question, how does the ERA blur those roles? Because the ERA is a very simple command, or would have been, that it had been added to the Constitution, prohibiting state, not private, but state discrimination on account of sex. And the concern, and here's a punchline for those of you who are students of constitutional law, and as most law students are, very eager to have your own views of morality written into the Constitution. Also a temptation judges fall prey to. And that is that the fear of the LDS leadership in the wake of Roe versus Wade in 1973 was that judges would interpret the ERA in ways that would undermine further the Mormon theology of the family. Abortion on demand would be entrenched. Homosexual marriages would be required in the prescient of the LDS Church. And the courts would strike down gender protection for wives and mothers. So in other words, the ERA, the fear was, would open up the family itself in ways that would liberalize and therefore disintegrate. Now that was the theoretical opposition to the ERA. The practical opposition is lethal to the ERA. Utah, as I said in January of 1975, was poised. About half of the legislature had stated its support for the ERA until an editorial in the Desert News announced its opposition. After the LDS Church announced its opposition, the legislature, by an overwhelming margin, rejected the ERA in 1975. Idaho, another state with a large Mormon population, rescinded its ratification a couple of years later. Nevada was another possible get for the ERA until LDS grassroots enthusiasm overwhelmed the ERA in a 2-to-1 referendum. Virginia, not a big Mormon state, but where there is a small and energized Mormon community in Northern Virginia, declined to ratify the ERA in 78-79 after a massive LDS letter-writing campaign. Something similar happened in Missouri, and there were some other states where LDS was involved. Ultimately, just 35 states, and as you can see, if you put together Utah, Nevada, Virginia, and Missouri, where LDS did have a major role to play, it is quite possible to say that LDS was instrumental in the defeat of the ERA. Big victory. After the ERA basically expired in 1982, another big issue that the church started thinking about was the quote-unquote homosexual agenda. And there's a document that Elder Oaks gave to the church, which lays out the church's response in the mid-'80s to what's called the homosexual agenda. And a lot of it's very interesting. Consensual sex, for example. You would think that, like other churches, the Catholic Church among them, that LDS would be in favor of criminalizing consensual sodomy and other non-procreative sex. The position of the Oaks Memorandum was, this is not an issue we should devote much time on, and we should not agitate in favor of any kind of singling out or special criminalization of homosexual activities. Anti-discrimination laws. You would think, well, does this promote homosexuality? And the Oaks' position on that one was also nuanced and very thoughtful. Generally, his advice to the church in the mid-'80s was take no position for the time being on anti-discrimination laws. The state once passed a law saying you can't fire someone as an engineer if she's transgender. This is not something that maybe we should be involved in, but we should insist that any anti-discrimination law have big allowances for discrimination or exclusion for possible role models. There should not be homosexual role models where children are involved. Boy Scouts, a very Mormonized organization, was high in their mind on that. And then Elder Oaks adamantly opposed homosexual marriage. Following this memorandum, and largely under the leadership of President Hinckley, the church did become deeply involved in a series of initiatives and referenda on gay marriage. Starting with Hawaii in 1998, the church gave a lot of money and some grassroots effort to an overwhelming victory for traditional marriage in that vote. Ditto for Alaska, a less publicized vote, same year. The church was involved in California twice in the famous Night Initiative in 2000 and the even more famous Prop 8 in 2008. Between June and November 2008, the church provided maybe as much as $20 million through its members, not through the church itself, and hundreds and maybe thousands of volunteers in California in a massive grassroots mobilization that, in my opinion, unquestionably propelled Proposition 8 to its narrow but decisive 52-40% victory. Same replicated in Maine later in 2009. Now, ironically, the short-term LDS success, and these are stunning constitutional moments, honestly earned victories, but they're successful only in the short term. And in the long term, there has been some degree of constitutional disappointment. So the ERA was never ratified, but the Supreme Court has implemented the ERA's agenda via the Equal Protection Clause in the 14th Amendment for the most part, culminating, of course, in Obergefell, the same-sex marriage decision this year. Marriage equality, again, the California Prop 8 was overturned by a district court, and in a shocking ruling, flawless in my opinion, the Supreme Court ruled in 2013 that the Prop 8 defenders who had worked hard for this had no standing to appeal the overturning. an aggressive and I think lawless use of Article 3 by the U.S. Supreme Court. So the virtuous but gendered family has taken these legal hits and sociologically continues to decline, giving way to the hedonic family. Now my one recipe there is that the LDS Church treated particularly homosexual marriage as the Maginot Line to protect traditional marriage against further liberalization. The problem, if you know the Maginot Line, is the line forts built by France after being slaughtered in World War I. And they built, not remembering that they had been invaded through Belgium, duh. They built the row of forts on the German border. And so the Maginot Line was ineffective for a number of reasons. It was built, it was sort of deluding them to think that they had security. But opposing gay marriage, it seems to me, was not only the mistake of the Maginot Line, but it was as though France had built the Maginot Line against Luxembourg rather than Germany. In other words, it was the wrong enemy of liberalization. And that's a disappointment as well. What lessons? Well, lesson number one is, I think, a lot of lessons about our Constitution itself. Our Constitution, I'm a legal realist, is posed. The Amars are very rigorous. These people believe in the rule of law. And more power to them. They're very important, and I'm not, but I'm right. And that is, constitutional law is not original meaning, the way it operates. It's not representation reinforcement. It's not common law. Constitutional law, particularly the individual rights feature, is an ongoing accommodation of competing social groups. It is often a compromise. And that's why you see religious liberty accommodations. Hobby Lobby is almost certainly an example. The de facto ERA, the Supreme Court didn't incorporate all of the ERA, just most of it. Second lesson, constitutional amendments are irrelevant. The ERA, I think, killed constitutional amendments in the individual rights area because it shows how arduous it was, and then you didn't need the constitutional amendment if you could persuade Lewis Powell to vote your way. The LDS Church itself was reluctant on the federal marriage amendment when it was originally opposed to prohibit same-sex marriage as a matter of constitutional amendment. Lynn Wardle, a prominent professor, opposed that in the 1990s, saying this should be a matter of local debate, should not be taken away prematurely from normative conversation, and I admire that. And my view is that the Supreme Court should be pluralism facilitating. The state must be neutral. So I think the state should recognize marriages between lesbians and gay men in the same terms as others. But it needs to give allowances for norm dissenters, which, by the way, before '86 was people like me, gay people. After 2015, it's going to be more religious minorities, probably than gay people. So let me give you an example of that. This is just a map I had in my file. In 2012, right before the election, this was the map of the United States. The blue states are domestic partnership and stuff like that. You notice there you are in Illinois. The red states are not like Mitt Romney states, they're instead marriage equality states. And there are, some, but not like gobs of them. In my opinion, the conversation about marriage equality was far from over. It was still in its discursive stages. Now this map suggests why it was more defensible for the Supreme Court to end the conversation in Obergefell, in other words, in 2015. All of the states that are colored are marriage equality. That's many of them by federal court order, admittedly, but a lot of them, as you see, by legislation. Those are the dark red states, and a number by state court orders as well. Here's lesson number 2, which I think is a very interesting lesson. And that is the relationship between constitutionalism and faith communities in the United States. And my thesis is that constitutional law and social norms, which are different, and religious doctrine are interdependent and not entirely independent variables. And I have a historical example, which is a Mormon example. But it's also, my own church is Presbyterians. I can tell the same story about them as well. The Baptists, Methodists, etc. And that is that in the early mid-19th century, the Mormons endorsed slavery based upon an old Protestant idea of Noah's curse on the descendants of Ham, who had seen his father Noah naked. And Ham was alleged to be the father of African races, and Noah had cursed the descendants of Ham to be slaves of the descendants of the other brothers. Brigham Young also endorsed Cain's curse as a justification for temple segregation, that African Americans, or Africans I guess generally, could not be full temple members of the church. And then the Book of Mormon does have discussions of the Lamanites, whose dark skin, by some interpretations, is supposed to be associated with impurity. Now these doctrines, slavery, segregation, and darkness as impurity, dark skin, have melted away through a complicated process in light of constitutional shifts, namely the 13th Amendment, which actually abolished slavery, and of course Brown versus Board of Education in that revolution. You see the same pattern, not necessarily going to be the same result, in the LDS practice and doctrine toward LGBT persons and couples. And it's a three-stage process, and the first two overlap considerably. Just as in the wake of the Civil Rights Revolution, we saw much more tolerance of racial minorities within the church, so we're seeing a lot more tolerance of sexual and gender minorities within LDS. One important moment was the suicide of Stuart Mathis in February of 2000, which triggered a cascade, a small cascade, of families confronting their LGBT children, Mormon families. In the LDS Church, many of you become missionaries, you don't know, and one of the missionary tropes is you want to try to convert other people, often in other continents. And what I'm told by LDS missionaries is that the most effective conversion technique is to tell your own story, how you came to God, how you came to believe what you came to believe. And that, I think, is what's going on in the LDS Church. That family after family is coming to grips with their lesbian, gay, bisexual, transgender children, brothers, sisters, etc. And they're having conversion narratives. Each narrative is different. Some people reject it. Other people become warm supporters, etc., etc. And we're seeing this at BYU. We're seeing it in local congregations. We're seeing it in Salt Lake City rhetoric in the last 10 or 15 years. Secondly, we saw this exactly in the LDS approach to race. And Robin Wilson has been key to this. Senator, our senator has been key to this. And that is support for an anti-discrimination bill. In the wake of Proposition 8, the church acquiesced in the Salt Lake City 2009 anti-discrimination ordinance for employment and housing. And then in January of 2015, this year, dramatically endorsed Senator Urquhart and Senator Adams' anti-discrimination statute pending in the Utah legislature, which, through the drafting and intellectual efforts of Professor Wilson, actually was adopted into law, twinned with protections for the conscience of clerks and others. Major achievement. It is the only time in my lifetime that a Republican legislature has created anti-discrimination protections for sexual and gender minorities. What about a doctrinal shift? We saw that in race. There was a revelation to the prophet in 1978, which ended the last vestiges of racial discrimination within the church itself. We've certainly not seen any shift, and after Obergefell, the church reaffirmed its doctrine. What I predict, however, is that in the next generation, there will be a shift in LDS doctrine away from the degree of the gendered family that you saw in the 1995 Proclamation. And it will be this micro process of conversion narratives within the church and pressure from social norms and constitutional norms outside the church. And then finally, and I don't want to try to skip on this, so I'm going to go a little bit over my time, is that the surprising lesson, this was a bit surprising to me when I was writing my gaseously lengthy article, was that the big lesson for me for LDS constitutionalism is that it reveals what I've never seen before and how central norms about the family are to the American Constitution. And not just obviously, sure, Loving versus Virginia, Obergefell, these are landmark precedents. Loving is different race marriage, unconstitutional bars. Obergefell is the marriage case for lesbian and gays. Well, obviously that's about family law. And then there are these older cases, such as Meyer and Pierce, which are cases about child raising. The Amish case, Yoder versus Wisconsin, the right of Amish parents to withhold their children from school and so on. Yes, those are all obviously about family. Obergefell is very important because it transports all of these privacy cases into the courts of liberty jurisprudence, which of course is a very, very big deal. But also it's important for equality, that equal protection for African Americans, for women, and for sexual minorities, these three very big litigation groups, centrally about family. That the core discriminations, which were the object of the civil rights campaigns, were the family-based discriminations. And the reasons for those discriminations were the central trope for why the groups were discriminated against in the first place. The most obvious example, well documented, I'm not saying anything new here, is race. I grew up in the South. Probably most of y'all did not. Y'all did not. In the South, the root stereotype against integration, interracial marriage, interracial dating, interracial anything, was the idea of the mongrelization of the human race through interracial mating and interracial children. And that was also the deepest prejudice. That was a stereotype. It was also the deepest prejudice. Because Southerners, including many people of color, were literally hysterical about the possibility of interracial sexuality, even when it didn't produce children. I would say for women, what is the deepest stereotype that the liberal ERA was confronting? The deepest stereotype is the idea that women's place is in the home, that women's role is to bear and raise the children alone, and that limits her to the domestic sphere and bars her, or at least disadvantages her, from the public sphere. Okay. For gay people, and I've written lots of books on this, this is what I probably know best, the central trope for homophobia or anti-gay rhetoric from the 20s and 30s onward was that gay people, homosexuals, whatever you call them, are sterile because they don't reproduce. Because they're sterile, they're selfish because they're incapable of the connection, the God-given connection, man and woman, children, the triadic thing. Because they're sterile and selfish, they are predatory, so they cannot produce children, and they're going to steal yours. And because they're sterile, selfish, and predatory, gay people are fundamentally anti-family. That's why 25 years ago, I represented the DC plaintiffs in the first modern gay marriage case, the first modern after Denmark. And that was my idea, that I felt the fundamental foundation for anti-gay discrimination was the idea that gay people cannot be family. And that, I think, is basically what was going over Obergefell. And finally, the First Amendment. The First Amendment is also family-driven to a very significant extent. And there we can bring in hobby lobby, free exercise rights, whether it's constitutional or RFRA, which of course is a statute. But also bringing it back to LDS, the rights of association and expression. One of the big First Amendment decisions of your lifetime is Boy Scouts versus Dale, where the Supreme Court held that the Boy Scouts have a First Amendment right of association or expressive association not to have an anti-discrimination law apply to their policy of barring gay scoutmasters. Now, I realize that's the process of changing, and the LDS seems to be going along with it. This is a dynamic thing. But query, if the Boy Scouts wants to exclude that, they have a First Amendment right to do so. And I think as you've seen from my address today, where they're coming from is this gendered theology of the family. And a lot of the First Amendment cases that you read, not most of them, can ultimately be traced back to some kind of theory of the family, whether you're talking about religious groups or others, and it ties into the First Amendment. So a lot of the Constitution family. Here's the deeper lesson, and I'll close with this. The deepest lesson of Latter-day Constitutionalism is if you read the Proclamation, the thing I started with back in 1995, there are a couple of different pitches you can take. If you're a liberal reading the Declaration, the Proclamation, the takeaway for me is the interconnection that the Proclamation reveals among sexuality, gender, and the law. And I've written a case book called Sexuality, Gender, and the Law, so I'm likely to see this. And what this brings home for me, and Elder Oaks said it himself in the '84 document, he says, homosexual marriages are wholly deviant to the patriarchal family. And I think the elder hit the nail with his head. That the central objection to homosexual marriage, if you call it that, is the sex discrimination argument. And that's been a staple. It's very rarely accepted by judges, almost never accepted by judges, and never by a majority since the Hawaii debacle in 1993. But it's deeply true that the exclusion of man couples or woman-woman couples from marriage and other rights where you accept a man and a woman is both formally sex discrimination, but it's also functionally sex discrimination because it relates to patriarchy. And there you have that document. That's the legal lesson. But here's the communitarian lesson. If you were a communitarian reading that proclamation, here's what you would take away from the proclamation, and I think it's equally worth thinking about. And that is that a central dilemma for the American family, to report, a la Andrew Cherlin, that the family has become individualized, this hedonic idea. When you think about it, you might think, oh, that's wonderful, and y'all are young and hedonic yourselves. But who loses from that? And there's a lot of evidence. You know, people like me criticize opponents of marriage equality for saying a lot of things about gay people that's not empirically supported. But a lot of the traditionalists, a lot of religious thinkers and sociologists have actually done their homework on the effects of single parenting, broken marriages, divorce on children. And yes, there's a lot more to be done. This is very complicated sociological. But they've done their homework. You can't just criticize them and say that the evidence is inconclusive. They've done their homework, and there's a lot of evidence to lead you to believe. Hank Brennick has written about this as well. That would lead you to believe that this is a real problem. And maybe the biggest challenge for America, American constitutionalism, is how do you inculcate other regarding attitudes for romantic partners? This is a problem of domestic abuse as well. It's not just children, it's also domestic abuse. This is violence against women. Other regarding attitudes for romantic partners and parents. In other words, truly self-giving attitudes toward one another, and then toward children if you're raising children in your household. Now, I don't think myself that self-sacrifice is advanced by gendered marriage. It might be something else. And Naomi Kahn, I think is going to be at this conference.
Is that the back of the
Oh, there's Naomi, yes. And Judy Carbone, who may not be here, have done something to advance our understanding. There's a lot of sociology trying to advance our understanding of that. And I think that's the great challenge. Amen. Thank you. Questions?
Yeah, we have time for questions.
We have time
I'm on task. No, there's got to be a microphone. It is being taped. Future confirmation hearings. Thank you so much, sir, for your talk. Well, I really liked it a lot. The main thing I think a lot about how laws emerge over long periods of time from more simple types of social systems, and so they kind of emerge quite often out of religious systems, and they kind of sit on top. And then I like this idea that you have about social norms, religious, and the norms coming together, how they all interact. This all seems right to me, and it also seems right to me that when that's happening, you get a lot of kind of tensions and also anxieties and fears and how are things going to move, and then that might play a much larger role in resistance to some larger constitutions than we might recognize. So I really like that part. It also seems to me that when these tensions occur, one of the things that I've noticed happen in a lot of the debates is that there are a whole series of phenomena that people think of as fairly timeless that are actually evolving much more than people realize. That goes in so many different. It's marriage, it's family, it's sexuality, it's race, it's it's virtue, it's it's gender. It's a number of these different things. People like marriage is about X, sex is about, or purpose is about X, and all these different things. What I see happening with all this is that there's a lot of evolution of people kind of trying to hold on to these kinds of things. It's some anxiety that's unwarranted. And really what I wanted to say is I buy the picture about the evolution, I buy the picture of all the kinds of details you're saying, but I want to push you on one thing, and I hope this is a friendly push, but make it unfriendly.
I'm really mad about something you said. I don't think this is a move from virtuous gendered marriage to hedonic ungendered marriage. I don't think, and maybe there's some openness here as to where it's going, but I think it's a move from virtue to virtue. And the reason I say that is because at its very best, the way that these things are going to be moving, it's not about hedonism. It's not about pure pleasure. It's about, at its best, it's about commitment, honor, honesty, symbolism, acceptance from the community. It could be about equality, making sure that children have stable atmospheres to live in. It could be, it's a whole range of things that I really, 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 really hope that you will not call it a move to hedonic marriage, at least as the goal of what some people are searching for in this kind of development. If it ends there, I'm gay, so then I'll actually start pushing more for traditional marriage and move against this hedonic thing. I would. And I don't think that's how it should be framed. I know it is sometimes framed that way, but I just don't think that that's, I don't think we'll look back on these changes and think that that's really what happened. I think it's...
Okay, let me clarify my normative position. I'm making an empirical observation. This is based upon the work of Andrew Cherlin.
Okay.
So I don't claim to be the original empiricist here. Andrew Cherlin, who's the leading sociologist, says this has been the movement in American family formation toward this hedonic idea. And I think that's right. Now, I think, is that normatively what we should be doing? Well, the last slide suggests no.
Right.
Now, and the reason I think that gendered marriage is not essential for this idea of virtue.
Yes.
I'm running this book, and the lead couple are the Michigan couple, the DePaul and Krause couple.
Right.
These are two nurses. They are raising 5 children. 2 of the children would almost certainly be dead if it were not for these nurses, because one of them, for example, little Jacob, was born prematurely. He was born at like 2 pounds, like almost 3 pounds, 2 pounds, like 12 ounces, something like that. The doctors gave him no chance. Crack mother. April DeBoer was his nurse in the child unit that she worked in. She and others struggled to save this child's life. The child did struggle through, but then the natal unit had done all that it could. The child needed to go to either foster or adoption. And DeBoer and Krause lived in different jurisdictions. It could be a state adoption. Well, somebody broke the rules and went outside the structure and placed the call to DeBoer and Krause.
who were already raising 3 children, which was about 1 child too many, and said, would you adopt little Jacob? And April, you know, when Jane Rouse was on the phone, April said, hang on, you're already getting too many, I know what this is, hang on. And Jane says, no, I'm going to keep talking. Hang on! And she said, it's Jacob. And they just broke down. And, you know, the 2 nurses, therapy, there had to be physical therapy, there had to be emotional therapy, there had to be treatment, there had to be round-the-clock, you know, care. And about 6 months later, after Jacob had come into their home, April brought him back to the hospital unit and ran into one of the doctors and said, do you remember little Jacob? And the doctor said, when did that boy die? I'm so sorry. And April says, he's right over there. You know, they're still working, but he is a beautiful, happy little child. Now that is absolutely a stunning story. Okay? So how do we inculcate more of that? Okay, and I think that's the challenge. And I personally do think, and this is this micro thing. See, I'm not going to tell you, here's what LDS is going to do 30 years from now. I can't even tell you what the marriage patterns are going to be 10 years from now. But we've got to find some way, and there are a lot of these micro stories, like in our family, very Southern traditionalist family. My sister and her partner raising 2 children, and everybody in our family, which is not like Philly bigots, everybody in our family, no, it uses Betsy and Lois as the model parents. Like, yeah, I wish we'd done what Betsy and Lois are doing, because they had children later than most of the rest of the cousins, all the rest of the cousins. Said, oh, if I'd known that, I would have done that. Oh, that's really smart. Their children are well behaved, they're interested in learning, they're adorable to other children, they're delightful, etc. You see what I'm saying? So that's where I'm coming from. And I think that's the sort of elliptical, that's what my book is going to be about. And that's the elliptical part of my talk. So there is that.
Thank you, Rob.
And objections. I like objections.
Okay, Leslie, that's a lot of pressure.
Not an objection, but maybe a different lesson that we might, depending on sort of where your preferences are, be less sanguine about, is one of the lessons that we should take from this, that for groups who don't want norm change, who are particularly concerned for their own group and how practice occurs within their own group. So, we don't really care what people of different religions do, but within our religion, we want to keep the norm regardless of what the law is. If the lesson of all this isn't fight harder, because it turns out that constitutional change isn't just legal change, but also social change, so that the LDS, to the extent that it doesn't want norm change, right, and the norm change has seeped in as a result of partially legal change, partially other things, is that it should fight harder. So I'm wondering whether that is another lesson that didn't make it up there.
Okay, I like that question. Honestly, I don't see what more they could have done. The Proposition 8 campaign, now my side was thoroughly incompetent in my opinion, so that helps. But the LDS side won fair and square. You know, it's like the Obama campaign. Obama won California by a large margin. LDS was like the Obama of the marriage fund. Though they were disciplined. Obama's disciplined, Biden's not. Obama's disciplined. They had a great grassroots turnout. And they had a message. They had a normative message. My side had lots of pablum about equality, not a lot of outreach in minority communities, some very inane commercials, and also some very insulting ones. There was a commercial called Home Invasion, which is kind of religiously bigoted, that was made in the latter days of the campaign, etc. So, honestly, I don't think they could have fought any harder. But you're right. I think you also have hit the nail with your head. I think that you're absolutely right, that a lot is at stake. So LDS, so one of the lessons of this, Gordon Hinckley was right. about this. And here's the problem, though. The problem is my Maginot Line problem. And it recurred in the oral argument, if I can tell an anecdote, it occurred in the oral argument in Obergefell. So the Chief Justice, very tightly wound Chief Justice, starts off the oral argument. Very good question, typically. Said, Ms. Bonato, the other side, their main objection is you're redefining marriage. And that's an awfully big move for the court to take, right? That's a great question. And that goes to the anxiety. This is one why there's a lot of anxiety. But the problem is, Bonato's answer should have been, here's what her answer should have been, and Ruth Ginsburg kind of gave her answer later on. What her answer should have been is, yes, Mr. Chief Justice, marriage has been redefined, but it's been redefined by the state of Michigan. The state of Michigan gives you no-fault divorce. The state of Michigan does not make it a crime to engage in adultery or fornication. Sexual cohabitation is fine in Michigan. In fact, they give you benefits and some protections in the state of Michigan. Illegitimate children are not penalized in the state of Michigan. And so on and so forth. So the state of Michigan has basically redefined civil marriage to follow the Churlin hedonic model. And the only people who don't get the benefit of this are lesbian and gay couples. So our claim is not to redefine marriage. Our central claim, and this is what Kennedy's opinion misses, our central claim is that we as a class, and in Michigan, it's not like they've been left behind, to use a metaphor. But Michigan had not only left the gays and lesbians out, they repeatedly bashed them. So in, I think, 2004, Michigan passed a constitutional amendment saying not only are we never going to recognize same-sex marriage, but not any kind of similar union. Okay, what's that all about? And then the Michigan Supreme Court interpreted the constitutional initiative to say that lesbian and gay people who have negotiated through their union for domestic partnership hospital benefits, this is a contract benefit, they lose that too, because that's similar to marriage. A contract benefit for hospitalization insurance. That's similar to marriage, because it involves two people. And then the bureaucracy did a workaround, and the legislature passed a special statute nullifying the workaround. No, you don't get your contract benefits that the administration is trying to give you. Okay? So that was our basic claim. That was our powerful claim in Obergefell. Okay? So yeah, I think LDS was right to stand up for what it believed and to get its message. The problem was, it's the Maginot Line problem, that their objection, and this is the dilemma, this is not like hypocrisy or anything like that, this is called a dilemma, that they've already given away the store for no-fault divorce. They gave away the store on sexual cohabitation. They gave away the store in not enforcing parental obligations, child support, etc., which are not seriously enforced in a lot of states, maybe most states. Then after giving away the store, the Germans are swarming through Belgium, they're swarming through Luxembourg, they're swarming through Switzerland, and you still have Alsace-Lorraine guarded. Or my alternative, you have Luxembourg guarded, and they're coming in through Alsace-Lorraine and not through Luxembourg. So that's the dilemma. That's the dilemma. So that's number one dilemma. Then number two dilemma, and contrary to what all the gay rights leaders will tell you, I will tell you, that gay marriage was inevitable. Why was it inevitable? I said that 25. I said this for 25 years. The reason it was inevitable is that there are among you, and always will be among you, lesbian, gay, bisexual, and transgender individuals. And we have a lot of the same aspirations. We form relationships. We form loving, committed relationships. A lot of us want to and do have children and raise children responsibly and with all the errors that other people make. All parents are represented by their children, justifiably, I'm sure. Okay? And that's a social fact. Just mention that. That's a social fact. That's a social fact. And it's not going to go away. And then that's going to create all of these micro stories. And particularly after Massachusetts recognized marriage equality in 2003, 2004, you actually had legal marriages and not just marriage ceremonies and whatnot. And I think that was the end at that point. And I will tell you, I've talked to dozens of supporters of traditional marriage, people who devoted much of their professional careers, and most of them, some of them like Maggie Gallagher, whom I adore, and I'm very good friends with her. She was a true believer for a while. Most of them, by 2004, 2005, realized they had lost already. Now, should I fault people for continuing to fight the good fight? No. But they had lost by then because of that social fact. And here's another social fact. This is a very efficient mechanism.
Well, actually, the most important.
Oh, no, there's something else.
Yeah, two pieces of business that we need to do. First, I want to recognize the law review for hosting the symposium. Mention to you that, yes, I actually need to recognize not only the law review, but the support of the DePaul College of Law. My co-conveners, Zoe Robinson, couldn't be with us, but they have provided significant support. Our new family law and policy program, and the Epstein program in health law. So we want to recognize that. And we have one other piece of business, which is coming from the family law program, and that is that we want to give 2 inaugural lifetime achievement awards in family law. To my knowledge, that's without precedent anywhere in the country. And I'm especially privileged not only to be having Bill with us as one of those 2 inaugural award winners, but also my former colleague and a dear friend, Harry Krause, who was on this faculty for a very long time. I spoke to Harry yesterday. He's not able to join us, and he felt terrible about that. He didn't know about this until maybe a week ago. Basically, this award is designed to recognize great scholarly contributions to family law. If anybody thinks this man hasn't done that, you weren't paying attention. But it's not only to recognize a contribution to scholarship, it is to recognize a felt impact on the law. And Bill Eskridge, at least as to gay rights, I don't know a whole lot about statutory interpretation, so I'm not going to talk about that. But as to family law and gay rights, I can think of no one else that has left a greater impact. So it's a deep privilege for us. I want to spend 1 second talking about Harry Krause, because one would think that you could not find a rival to Bill Eskridge. And yet Harry, during his career in family law, left a measured impact on the contours of family law. He was, on behalf of the U.S. State Department, a delegate to the Hague Conference on Private International Law. He worked, as you know, Merle, on the Treaty on International Adoptions. He was the reporter not for one Uniform Act, the Uniform Parentage Act, but 2. He was also the reporter for the Uniform Putative Fathers Act. And maybe even more important, that resonates with something that Bill said just a few minutes ago, Harry did yeoman's work in making sure that we don't make illegitimate distinctions between families and discriminate against them. And in particular, he was one of the early people to stand up for non-marital children, to make sure that they receive the same rights as marital children. And that led proximately to the decision in Levy versus Louisiana, which some of you have read, and perhaps we will read this year in family law. So for me, I can think of no scholars of family law more deserving than these 2 gentlemen for their recognition, not just recognition, but for our gratitude and making families better than they were when they found them.